All right. Welcome to the Planning and Land Use Management Committee. Been joined by the Honorable Paul Wisat, with the article on accents, and he don't even know stinking classes. We have a few items today, and I won't jinx it. I won't say how fast it'll go. We'll just go through it. But I do want to welcome one of our first guests, who is an appointment as communicated by the mayor for the North Valley Area Planning Commission. And I want to thank her for being here. And I didn't want to keep her too long, knowing that she has a tiny baby with her. Ms. Vo Ramirez, is that right?
Yes.
Good morning. Please give us your name and the name of your baby.
Good morning, council members and staff. I'm Quinvo Ramirez. I'm also the Selmar Neighborhood Council president. And Nicholas Ramirez, our 2-month-old, is with me today, and I'm very blessed to have my father-in-law babysitting him while I'm up here.
Okay, well, congratulations.
Thank you.
Well, first of all, I just wanted to thank you for stepping up to the plate. This is a very demanding committee.
Yes.
And could you just share a little bit about yourself with us, a little bit of your background?
I have a few degrees, one of which is a master's in landscape architecture.
I'm curious, what are the other ones?
Biology, art history, and ornamental horticulture.
Wow, that's all in 4 years.
4 years, 2 years, 3 years.
Okay.
A student for life.
Great, good for you.
And my experience it actually ranges. I've worked on small residential projects all the way up to 2,000 acres, anywhere from single residential homes that could be 44,000 square feet to regional plans, master plans, multi-development, mixed-use development. I've worked across jurisdictions and as well with multiple agencies ranging from Army Corps to Sierra Club to developers to communities like neighborhood councils. So it's kind of broad.
Great, so you've been introduced to the array of issues and the spectrum of concerns that deals with development.
Yes.
Good for you. So you know exactly what you're walking into.
Yes, I know what I'm getting myself into.
One of the challenges we have as a city is finding ways to provide opportunities for housing for people that live here.
Yes.
And trying to get them closer to their workplace.
Yes.
Closer to transit facilities.
Yes.
And so the role of access for especially the working folks in terms of mixed income environments, what's your orientation in that regard? How do you see that whole dynamic?
I think that is a very challenging situation that we face, especially with population growth and with the diversity of the city of Los Angeles itself. But I'm hoping as a commissioner with my experience and academic background that we can strike a balance between immediate use, such as preserving historical communities, but while enhancing others that may have not have the same opportunities. For me, I think one of the more I would kind of strive for is mixed development use, live where you work, so there would be less impact on transportation, and hopefully when it's your own affordable housing. But I think it's something that we all need to work on together, because it's not just a policy issue, it's not just a community issue, it's kind of a wide spectrum.
Thank you for that. which is joined by Councilor Jose Rizar. Thank you, sir. Welcome. So we have a candidate for the North Valley Planning Commission. And any questions from my colleagues for our candidate? Or any comments?
Thank you, Mr. Chairman. I just wanted to say that I have the honor of representing much of the North Valley and the community of Sunlandahunga, and you are going to be taking on a task that is going to be a difficult one. And these are communities that have tremendous diversity of income level, of geography. I mean, you have everything from some of the most dense residential areas to industrial areas to some very rural and equestrian areas, all within the same area. And so it's going to be a challenge, and it's a challenge to be respectful of the distinct nature of each community. So I very much appreciate your comments about working with neighborhood councils and some of the other stakeholder groups and trying to be respectful of the distinction that we have among communities. That's very important to me. So you're going to be working with a great group of colleagues on the current Area Planning Commission, and I'm very much looking forward to having the chance to work with you.
Thank you.
Great. Councilmember? No? Okay. Well, I would like to move for approval. And that's been seconded. That's a yes? So it'll be unanimous recommendation from this committee to the council. And when is the council? Tomorrow. Okay. So
I'll see you again tomorrow morning.
Okay, so hopefully Nicholas will have enough sleep.
Yes.
And it'll be an environment where hopefully we can get you in and out should we need to.
Thank you very much.
Okay.
Thank you, council members.
Okay, well, thank you for your help.
Thank you. Have a good day.
Okay, thank you. All right, that's item number 1. We do have the ZA who has an APC hearing at 4, and that particular person handling the case, and maybe we should do is go a little bit out of order, and so allow her, hopefully, the time to get to your hearing, APC hearing. And so, Roberto, you want to read number 4?
Sure, council members. Item 4 is an appeal by Jim McQuiston. He's appealing the action of the Central APC, which overturned the zoning administrator's approval of a variance to permit 3 dwelling units in lieu of the maximum 2 units allowed in the R2 zone in Council District 5.
Okay, and just before you start, number 2 does have cards, so we'll call that special. 3 will continue in Plum to April 24th, hopefully in council by May 8th. 4 we are dealing with now, and 5 also has cards, so both 4 and 5 are special. And the director's not here today, so we'll not be hearing from the director. So, please continue.
Good afternoon, committee members and President Reyes, switching with the City Planning Department. This application is a zone variance application to allow the 3rd dwelling unit. Actually, this site is a zone for an R2 that permits a maximum of 2 dwelling units. According to the building permit record, the existing duplex constructed in the early 1920s. In the early 1990s, the detached garage was rebuilt. In year 2005, right before the prior property owner sold this property to the current property owner, a recreation room was built that was also detached in the rear of the property. I believe in year 2006, the current property owner purchased this property as is, as a 3 dwelling units, and the 3rd dwelling unit was converted to, the recreation room was illegally converted without permit to the 3rd dwelling unit. That's the subject unit before you under this application. original zone variance application was denied by the zoning administrator. The applicant appealed their decision to Area Planning Commission. Central Area Planning Commission granted the applicant's appeal, made findings to support their decision. The third dwelling unit was conditioned to be reserved as 60% AMI affordable housing unit for 30 years. Now, the APC decision was appealed by the appellant here today. So if you have any further question, I'll be available.
Okay. Any questions for our presenter? Seeing none, we will go ahead and hear from the applicant. I believe, Mr. McQuiston, the grounds for your...
The appellant.
Appellant for your appeal? On the appellant, no, we'll give him some flexibility.
Jim McQuiston. This is a very difficult appeal, you might say, because it's not an appeal, it's a point of order. The problem on this particular part of Hollywood, the property owner took out a permit this year to build a recreation room and put in a bath and put some various things in, and then proceeded to live in that particular part as a third unit. He bought the property, according to the assessor, in 1906. So there was no zoning irregularity or anything like that. I've given you a statement which more or less sums up in a few short words the problem, namely the CAPC, in trying to overturn it, of course, as you know, didn't quite follow the code, but they put out a set of rules, and they said, well, we can't approve this unless these things are done, and we want to see some proof of this before we make it final. And that was done in July. And in July, that was the second hearing. And so it was running out of time. And they said, well, before we have the second hearing, you have to authorize an extension of time. And the applicant extended the time until the day after the hearing, And that's in the file. And you have a copy of the extension. I just circulated it. Now, the problem is that the CAPC said, well, we're not going to approve this unless certain things are done. And it's going to take at least 2 weeks to find these out, maybe 30 days. Actually, so they put out a memorandum, you might say, in August, which is beyond the time which the law allows the CAPC to have jurisdiction. And I didn't realize that they hadn't had jurisdiction, so I said, well, please reconsider this. And I got a call from the zoning administrator saying they lost jurisdiction. So I checked the file, and sure enough, that is the evidence in the file. So that means that the city council can, if the applicant appeals to the city council, do the work according to the code. But the CAPC's decision is not a decision because they lost jurisdiction. Now you can see where I'm left off. I can't really talk about why the CAPC erred because they lost jurisdiction, so it's a nullity. We can't talk about that. On the other hand, I support the zoning administrator. She did a good job on this, and the decision that she handed down is correct. And the rules say that if they lose jurisdiction, you have to go by the zoning administrator's decision. Now you, on the other hand, are usually the city council, your legislators, but in this particular case, you're not. According to 1094.5 of the Code of Civil Procedure, you're acting as, you might say, judges rather than legislators. So you can't do anything except find errors in what happened. And the major error is they lost jurisdiction. So what is the quick and dirty solution is to say, yes, that's true. You lost jurisdiction. It can be appealed to the city council if the appellant wants to, but otherwise it's over and done. And that, I think, is the proper solution. Now, I can go into any of the points that you want. As far as the decision is concerned, McQuiston versus March, which happened in the Ninth Circuit in the federal system, said that every decision has to be accompanied with points and authorities so that the reasoning for that decision comes out. In this particular case, we don't have any points and authorities until August, and that was at the time when they lost jurisdiction. There were actually 5 different things they said. 2 weeks after July 26th, there must be a finding to be written and proving 3.5 units per block, 12 average, or there's no justification for this. Okay, there was nothing ever put in on that particular point, but the actual from the city record is only 2.07 for that particular area, so it couldn't possibly have happened. Then you say, okay, you must prove that the zoning was R3 when the conversion to 3 units occurred. But the city records show that the zoning was, in fact, R2 and not R3. So this means that there was a whole bunch of things that were asked. Another one was to provide the evidence that the applicant no longer occupies that particular location, and yet in your file, in the council file, there is a submission October 20th with his address, that particular address on it. So he's still occupying it. And then it said provide clearance within 30 days considering the restrictions imposed by the fire department and building and safety. And they said also, depending on what building and safety says, the matter may have to be resumed. Well, this is long after they lost jurisdiction. So these things, these points, are still something which can be considered, but not by that, and we cannot go by that decision. Now, on account of that, that means that the zoning administrator's decision, unless appealed to the city council, which has not been appealed to the city council, will stand.
Mr. McQuiston, I appreciate what you're saying, and I just, if you don't mind, I'd like to have the staff and the city attorney help me respond to your assertion. So if you mind taking a seat, and I'm going to ask questions regarding your assertions here.
I'll save time for rebuttal.
Okay, thank you. Still like to come on up. I think one of the fundamental assertions that are being made is that the commission lost jurisdiction on this, and then from that premise, other issues begin to, tumble forward. And so I wanted to just start with that point, Mr. McQuiston's observation. Can you respond to that?
Okay. I'll give you a little timeline how the ZA decision to today's date. ZA denied this application and a letter went out. The letter dated April 14, 2011. So the commission has 75 days to act on this case. The 75 days will expire June, I cannot read very carefully. So actually from the last day of expiration of that appeal period. So ZA decision was made on April 14th. So last day to appeal, the ZA decision was April 29, 2011. So Commission had 75 days from April 29, 2011. That was I have that date, 75 days. So that is, I believe,
City Attorney, perhaps we could, what's our time frame on reviewing this case?
Terry Kaufman, Messiah City Attorney's Office. As I understand the issue, the appellant is looking at the date that the written determination was sent out, not the date that the APC acted. So the APC, as I understand it from speaking with Ms. Chang earlier and looking at some of the documents, was July 26th. And the commission and the applicant agreed to extend jurisdiction to the 27th. This August 15th determination is just memorializing the action that the commission took on the 26th. So I don't see there's a loss of jurisdiction here.
Okay.
well, I have an exact date. Commission had time until July the 13th. However, the first APC meeting was, on this case, was June 28th. That's within the time limit. At the first meeting, APC continued this case to the next scheduled meeting. That was in July. At that point, the applicant submitted the written consent for continuance. So the continuance was until July the 27th. So as our city attorney mentioned, at the second meeting, that the APC granted the appeal, that was still within the time limit. Whether or not the actual letter of decision should be within the time limit, according to our city attorney, the letter of decision is just to memorialize the APC action which was taken within the time limit. So, in my opinion, that APC acted on this case within the required time limit.
Okay. Ms. Chang, in terms of the other issues that have been addressed by Mr. McQuiston, can you give us some feedback on those assertions?
Which feedback? I'm sorry, I couldn't.
There are certain statements he is making regarding your decision on this case. Can you elaborate a little bit further as to your response to his observations?
Other than this, the expiration of time to act, my decision was to deny, but Commission overturned me with the revised findings, and I'm not here to defend my decision. I'm here just to give you the history associated with this case. And whatever decision this committee will make, I think you should evaluate whether or not the Commission findings really support their action. So I don't think I can further comment on that.
That's
findings.
Fine. We do have some cards on item number 4. Mr. McQuiston, can you just give us, give you 2 minutes? You did ask for rebuttal. I usually don't do this, but I'll give you 2 minutes just to rebut.
Jim McQuiston, as you know, 1094.5 requires findings before a decision is a decision. And we've had a lot of cases. Every case that's been taken to a court has said these do not constitute proper findings, and therefore the decision is vacated. Now, if the decision is vacated, that means it never existed. And the problem is that we need to have a city attorney present at these CAPC or all APC hearings, and there's none there now. And that's a major complaint that I have, and I notice, I've put it in my writings there, but until, you remember, if you want to look at the transcript for that hearing, which I don't have with me, but I've listened to it, I was present at that hearing, and I made my notes, and my notes say that there was no decision at the hearing. What they said was, if you can produce these things in 2 weeks or 30 days, then we will have another hearing and agree to these. And they didn't have that hearing. I requested a reconsideration on that, and at that time, our esteemed colleague here, zoning administrator, called me up and said, they've lost jurisdiction, so they can't have the hearing on this. And that is a fact. And so what we need to do to get out of this so we don't have another lawsuit is to say, look, it's null and void. Why don't you appeal to the city council and we'll discuss all these things according to law rather than trying to get a mishmash again. I just, you know, I just don't want to see the city getting into all these mishmashes.
Thank you, sir. Okay, we'll go into public comment cards, and then I'm assuming, Mr. Coons, that you... Yes, sir.
Do you wish to hear from the applicant, Councilman?
Yes, I was going to go there. Since you're from the applicant, next coming up, I believe that's Mr. Shahanian? Charles? The applicant? Come on up.
Good afternoon, Mr. Chairperson, committee members. I'm Christopher Murray. I'm Mr. Shanayan's representative.
Okay.
I'm not here to talk about the legalities of it. I leave that up to the city attorney's office. Frankly, I'm just here to answer any questions that you may have regarding the process we've done thus far. I do want to add, however, that the Central Area Planning Commission did vote on this particular measure and agreed to it. And yes, there are conditions of approval, but those are to be satisfied in going through the process, not that we needed to satisfy those first before we then went back to Central Area Planning Commission. I think the record's pretty clear in terms of the decision. With that said, I don't want to take up any more of your time at this point. I'm going to turn it over to Charles Shanayan, the property owner and the applicant on this particular project. Thank you.
Okay, thank you.
Good afternoon, I'm Charlie Shanayan, the property owner. I just want to say that I agree with the Central Area Planning Commission's decision. Before the process ever started, I got full signed approval from all adjoining neighbors on all sides. I went to the Greater Wilshire Neighborhood Council and got unanimous support from their land use committee, and then I took it to the full Greater Wilshire Neighborhood Council, got unanimous support from them. I have not had one neighbor in my 500-foot radius who has been against it. I'm available for any questions. Also, I'm very happy to be adding a low-income affordable housing unit to a neighborhood that really needs it.
Thank you, sir. Thank you very much. Any questions for either speaker? Okay, Mr. Coons, representing the district.
Christopher Kuntz, on behalf of Council District 5, Councilman Paul Koretz. In support of the Commission's decision and against this appeal, we were very pleased with the Commission's decision, which allows an affordable unit to remain in this part of our district. Sycamore is a street that has apartment buildings but was subsequently downzoned to R2. This fixes a situation with an existing unit there. And just as a reminder, it was supported by the surrounding neighbors as well as the neighborhood council. And I think the issue of the continuances I don't think that's a procedural problem. I don't think it's a legal problem. But I think it does show this committee that the APC took this case very seriously. They heard it a couple times. They wanted revisions to the findings, and not until all of those factors were satisfied did they grant the approval of this unit. They did so carefully, and we'd ask that you uphold that approval.
Okay, thank you. Any questions for the representative? None? Okay. Thank you, sir. It just seems to me that we have thoroughly vetted this issue on several rounds before it got to this committee. And Madam Attorney, just for the record, in terms of process and what's in front of us, can you just speak to that so that we can make a decision?
Terry Kaufman, Messiah City Attorney's Office. I don't see anything that looks irregular as far as the process. I see in the determination conditions that were required by the Commission on July 26. I see findings that were made on July 26. There was a mutually agreed extension to July 27th, so I don't see any reason why this body can't make a determination. I'm assuming that Mr. McQuiston, when he asked the zoning administrator about reconsideration, it may have been after the 27th, and then that would have been true as far as losing jurisdiction. But of course, he would have appeal rights, which he exercised.
Okay.
So I'm not seeing any impediments here.
Okay. So, colleagues, given the statements made by the applicant, the level of review that's been demonstrated in the record, the posture of the council office, I don't see any reason why we shouldn't support CPAC and move this forward. Is there a second on that?
Second.
Okay, so that'll be the action of this committee?
Or deny the appeal.
Yes. Roberto, I think I took away your job, didn't I? You haven't introduced an item yet, so go ahead.
It's about legitimacy.
Okay. All right. So we've taken care of one. We took care of four. I know you have a date and a deadline to meet, so she's going to go to an APC hearing. Item 2 does have cards on it, and it's, can you read that into the record, Roberto?
Sure. Item 2, council members, is a proposed ordinance to regulate farmers markets in the city, in the R zone, and also in the commercial, manufacturing, and parking zones.
Great. Can we have staff come forward? Item number 2. Good afternoon, ma'am.
Good afternoon. Nicole Sanchez with the City Planning Department. I'll be talking about the proposed certified farmers market ordinance. The intent of this proposed ordinance is to expand where certified farmers markets are allowed by making the permitting process easier to encourage access to fresh foods that certified farmers markets have to offer, especially in food deserts throughout the city. This ordinance does this while also preserving the neighborhood protections through performance standards and requirements. This ordinance was drafted in response to Motion 10-1832, which was introduced by Councilman Weston in November of 2010. On April 26, 2011, planning staff made a report back to Plum proposing the same processes you have before you today. The 60-day comment period for the public was then opened with a public hearing held on July 20th. The proposed ordinance was then approved by CPC on September 22nd. Today, certified farmers markets are not allowed anywhere by right. So we anticipate that with the 2 processes proposed in this ordinance, certified farmers markets will now be utilized as neighborhood amenities and not just destinations. And to be clear, this ordinance addresses certified farmers markets, meaning they have to be certified by the State Department of Food and Agriculture before they can come here and apply for a permit. So that does not include regular farmers markets or swap meets.
Great. Okay, let's go to public comment. If you have any questions, we'll call you back. Okay? So we'll dig in. We have with us Barry Johnson, Jim McQuiston, and Christina Spitz. Just keep your eye on the clock. Give us your name and address. Please, sir.
Barry Johnson, Studio City Neighborhood Council, Government Affairs Committee member. We have turned in a community impact statement that's part of your packet today that has come to you since the agenda was printed, and I just wanted to make you aware that you have that. Speaking personally, I would just like to say if it's not triple-size McMansions in your backyard or grandfathered sign districts, now it's going to be a farmer's market in front of your house without any knowledge to me. One morning I'm going to wake up and outside my yard on my street is going to be a certified farmer's market. Whatever happened to the notion a man's home is his castle? No matter how small my home may be, it's still the only castle I'll ever have. And I just think that allowing this with a ZA blessing is wrong, and that a certified public market in any residential zone, particularly single-family residential zones, should only happen if, for example, you garnered 75% of the signatures of that street. But just for it to arbitrarily happen without me even being asked as a homeowner, I think is wrong. Thank you.
Thank you, Mr. Johnson. Similar question?
Jim McQuiston. My personal problem, of course, with this, as a property owner, is in restricted industrial property. And the way that it was advertised in the materials was manufacturing. Now, if you make a restriction, a distinction between manufacturing property and restricted industrial property, then as far as my property is concerned, I have no problem. However, I must say this. In my factory, I was prevented by the police from entering my factory and doing work because someone decided that the street, which is part of my property, would be commandeered for a farmer's market. And we had to shut down the entire day because the police said, if you don't leave, we will arrest you. Now, that's wrong because that area says there's no commercial activity allowed in the restricted industrial area. And I wrote a very hot letter to the city attorney, and that market was killed, and it was not put back. Now, if they can come in by right on this, we were not told before that there was going to be one there, even though we were the property owners. That's wrong. So I am speaking only for the restricted industrial properties. But I do want to say that everyone owns to the center of the street in front of their property, and only a permission to pass over was given to the city that I have looked at. And so I think there is some grounds for caution there.
Okay. Thank you, sir. Our next speaker, we have Mr. Andrew Weston. Good afternoon, sir. I'm sorry, Christina Spitz. I'm sorry. My apologies. Good afternoon, ma'am.
Good afternoon. Thank you for the opportunity. My name is Christina Spitz. I'm chair of the Land Use Committee of Pacific Palisades Community Council. We've been down here on many issues before, and we did write a letter indicating some concerns with the ordinance, which we finally had a chance to look at in the last few days. I did want to say that we spoke to Mr. Rothman this morning, who allayed many of our concerns, so I don't want to belabor that letter. I do want to address a couple of concerns, however. One is very important to us, which is we've suggested that really neighborhood councils and community councils, which we are a community council, receive advance notice, if possible, of a project that's proposed. That way, it's not for the purpose of, blocking these farmers markets. We want to see fresh food everywhere, and because we're privileged to live in an area that does have a farmers market, it's not that we want to see no more farmers markets. What we would like to do is be able to work with the operators, as we do in many cases. For example, when there are street closures, we get advance notice, and the operators come and work with us, and we work out, so it's a win-win for everyone. So we'd like to see the ordinance provide for advance notice to neighborhood councils. The other concern we had to do with whether or not the findings that are applicable to conditional use permits are also going to be applicable here. And Mr. Rothman did indicate to me that would be true. I know there is some issue because the core findings ordinance hasn't been officially adopted or enacted yet, and that may be one reason why it was deleted. But we would really like to see that language either put in or clarified. Maybe, I don't want to put Mr. Rothman on the spot, but maybe he could clarify that. Those are our two main concerns, and we appreciate the time you've taken today. Thank you.
Thank you, ma'am. Now, Mr. Rostov. Thank you, sir.
Good afternoon, council members. Andrew Weston, Assistant Chief Deputy to Councilmember Weston. This is an ordinance that Councilmember Weston had initiated because it came to our attention that the farmers market in our particular district, which is located on Washington Boulevard in the parking lot of a church, was not properly permitted. And when going through the code and looking at a lot of the different farmer markets throughout the city, it came to our realization that there were probably multiple farmers markets throughout the city that weren't properly permitted under the code. And so we've been working with the planning department, and we feel that the planning department has come up with an excellent ordinance to address those permitting issues and to really allow for a process for farmers markets to take place, not only in the other zones, but also in the residential areas where they made sense. And we feel that that process works very well. There's only one slight issue that we have with the ordinance. It's not something that affects our district, but did want to bring to your attention. Under Section 2, which deals with paragraph 10 of subsection A of section 14.00, and this is dealing with certified farmers markets performance standards on page A4, I believe. At the bottom of that, there is a performance standard that deals with parking, and that performance standard says that the temporary use of a farmers market located on a parking lot shall not use more than 20% of the required spaces for the main use of that parking lot. We think that standard is too low and have talked with staff about it, and we would recommend that standard be changed to 50% instead of 20%. But other than that, we think this ordinance achieves exactly what we intended it to, and will be of a great benefit not only to the city but also to the certified farmers markets throughout the city. Thank you.
Mr. Weston, in terms of changing it to 50, can you just describe to me the intended goals of making that change?
Sure. And so from our understanding from staff is that there was no real analysis done on a particular number or percentage that was set in the draft ordinance. If you think about farmers markets, at least the ones that I've been to throughout the city, typically, obviously you don't want them to take up the entire parking lot, but they take up a lot more than 20% of parking lots, particularly in smaller, denser urban areas of the city. And so it just seemed to make sense to have a higher threshold there, or in essence really a lower threshold in terms of the percentage of the parking lot that would be available to vendors for a particular farmer's market.
Okay, thank you, sir. Thank you very much. Let's have staff come on up. And I just wanted to, because it was stated in public comment, I want to hear a response on the public record. But the notion that a farmer's market can pop up in front of anyone's home without any kind of notification, is that possible?
Tom Rothman, Planning Department. Assuming the home is in a single-family zone or any other residential zone, no, that's not possible. All of the what Nicole described earlier, when an applicant wants to place a farmer's market in a residential zone, they have to apply to the planning department and get approval from a zoning administrator, requiring a public hearing and public notification. So there's, and we also have requirements on there that are not just going to be conditions of approval, but requirements for farmers markets in residential zones, in addition to the hearing and the public notification.
So if
it could not be a by right, but we are allowing by right in the commercial, industrial, and agricultural zones with performance standards.
But I am hearing that there will be, given how you have described it, a layered approach to the notification. So if it's going to go to residential zone, property owners will be notified, the local stakeholders will be notified, as well as the council office.
Yes, we have an early notification system. When any application comes to the planning department, we notify all of our all the neighborhood councils, and with the process that we're talking about, all of the neighbors, all of the abutting owners of properties will be notified in addition.
Okay, so I want to make sure that was clear on the record.
Before the hearing and before anything really happens.
Charlie Roush, Planning Department staff. I think what may have been alluded to, and that's a condition for a hearing is not required. Sometimes the Office of Zoning Administration waives public hearings. The ordinance has language in there regarding that, and it requires the written approval of all owners who are adjacent to it, across the street from it. So basically anybody who would have received a public hearing notice would have to sign off that they agree with it. They also require 60% of the people within a 300-foot radius have to sign off on it. So people, not just the adjacent property owners, but people within a 300-foot radius need 60% of their signatures in order to do this. And our standard operating procedure in the Office of Zoning Administration is we don't approve these until we have more or less a letter from the neighborhood councils and from the affected council office before we waive public hearings. So.
My understanding there'll be some type of review period. Let's say all the T's are crossed, all the I's are dotted, but
Correct.
Something happens in that site, that area, unforeseen. We are able to review that location and the permit?
Even at that time, the determination is sent out to the adjacent property owners, and they can appeal at that time if they didn't like it.
Okay. Now, when the approach that Mr. Westall and Councilmember Weston have taken, it sounds to me they're addressing to fulfill a need where nutritious and or organic products are not available to certain neighborhoods for whatever reason, that these become opportunities to allow for that type of access to neighborhoods who traditionally would not have had access to it. Can you speak to that in terms of...
Certainly. The original motion, as Mr. Westall said, was to allow them by right in residential zones. We really just examined our current policies, and we did see the need for expanding where farmers markets can go in the city. We have lots of parts of the city that have very poor access to fresh fruits and vegetables. So we wanted to essentially ease up our restrictions where we can. And in some places, some of our single-family neighborhoods could use a farmer's market, but we wanted to make sure our neighborhood protections were in place, and we also have made it now easier for them to go into our commercial zones while still maintaining some type of neighborhood protection. So we are really trying to open up our neighborhoods and many parts of the city to have farmers markets where they were previously prohibited.
And the certification in of itself will allow us the strongest permitting process that maintains a focus just on those produce and those products as opposed to artisanry work or other kinds of goods that you might find in other locations. This is just restricted for edible food products.
So we actually renamed the section of the code that talks about farmers markets to be now certified farmers markets. And a certified farmers market, as Nicole said earlier, is certified by the state. They can only have farmers selling the produce that they sell on their property. They cannot expand it to crafts or prepared foods. This is simply a certified open farmers market, not what we see most commonly throughout the city. And again, we're talking about private property, not in the public rights of way.
Any other questions, my colleagues, on this? Councilmember?
Thank you, Mr. Chairman. A couple of things. First, I perfectly understand a hearing is not required if the abutting property owners and so on sign off. But is there something in the code or in this ordinance that requires advance notification of the surrounding property owners? That's the part that I was a little unclear on. Pacific Palisades Community Council proposed some language to ensure that within a 500-foot radius, written notice would be provided as well as to the neighborhood councils. Is that already existent in the code?
Yes, it is. It does exist. If we're talking about the single-family neighborhoods, they're going to file an application Our application process requires early notification to all neighborhood councils, so they will get a listing. In addition, when the application starts to be processed, we will send out notification to the abutting owners in addition to the neighborhood council. There is no notification to a community council, which I think they did mention. We can look into that. That's not part of our current process. We really only send out to the neighborhood councils, but we will be sending notification out.
And how about the 500-foot radius property owners?
Right now, our proposal is abutting owners only. This is a process that is similar to our conditional use permit process. Our conditional uses require a 500-foot notification. This is the further authority of the zoning administrator. As I like to call it, I call it the mini CUP. It's just to the abutting owners, and you can waive the public hearing, whereas our conditional use permits are a required public hearing and have a larger notification. This is a smaller notification and eligibility to waive it when everybody signs off. So if we were going to change our idea to notification, we would have to most likely move it to the conditional use section. And again, we're trying to make this as simple as possible to get markets to come in. So that's really our intent here, to make it simple, easy, and I think, as Charlie said earlier, the zoning administrator, when they approve this, they are going to be required to ask for a plan approval within a year. We could change it to 6 months, just make sure that if they're operating properly, if they're not operating according to all of our 8 performance standards about noise, hours of operation, trash, cleanup, lighting, all of those things, they can have their permit revoked.
Okay. But in any event, the neighborhood councils and the council office will be notified in advance. Okay. Now, on the parking issue that Mr. Westall mentioned, the change from 20% to 50% of the parking that would otherwise be available for the main use of the parcel, that makes perfect sense to me, except in the situation where the main use of the parcel is going on at the same time that the farmers market is going on. If it's a church and it's a Thursday farmers market, that would be fine. But if it's a church and it's a Sunday farmers market, or if it's a farmers market that goes into a shopping center parking lot while the businesses are open, that could create a significant spillover parking problem into the surrounding areas. That would be my concern. Is there a way that we could craft that to avoid that overflow parking problem?
We talked a lot about that when we were writing the ordinance. It was kind of a tricky thing. You know, there are some farmers markets that go into large malls that certainly don't need any more than 20%, and then they would want to go into smaller parking lots. And again, they could be at a time when the main use is closed or the main use is open. So we could certainly try to craft some language.
It might not even be necessary to be in ordinance language, as long as there's some process in place within the department to ensure that is taken into account. I don't know, but that would be my biggest concern about making that change.
Perhaps we can create a range, and depending on a case-by-case basis, work on that range, as long as there is a primary use of parking is not compromised. It would address, I think, your concern.
Yeah, and maybe some language in there that just says that the overflow parking impact will be, one of the factors to be considered by the zoning administrator in the approval process, so that the unique situations of a given parcel in a given neighborhood on a given day can be taken into account by the ZA.
Right, and it can certainly be looked at by the ZA. Right. And it could certainly be looked at that plan approval time, either the 6 months or the year after the adoption. We could probably have that as one of the criteria to relook at it, to come up with another condition, because this is somewhat uncharted territory.
Thank you.
Okay. Councilman? Okay, Ms. Sanchez, anything you'd like to add in terms of this? Okay, well, good job, team. So we could move this. Request the city attorney prepare this ordinance. I can move it to the city attorney.
And along with the amendment suggested by Councilman Krikorian, as to the spillover and the parking issue.
Absolutely. Thank you, sir. And just for a moment, colleagues, I'd like to reconsider item 4, just so I can read into the record the proper language that gives the clearest directive as to our intention on that item. So we can reconsider it. We'd like to deny the appeal, and to 3, adopt findings and conditions of the Central APC.
So, Terry Cropper, Macias, just to be precise, if you want to reconsider, you have to move to reconsider, take an action on that, and then,
Right.
yeah.
So let's
Move
vote to reconsider.
reconsideration.
Move reconsideration. 1 second. So now we are reconsidering, and now we move to deny the appeal and to adopt findings and conditions of Central APC.
Of the Central APC, right. I think that was your intent, but I want it on the record. Thank you.
All right. So it's been second moved, and that's the order on that item. So that takes care of 4. Roberto, what's next?
That would be the last item, item 5, which is an appeal by Joe and Arit Picker. They're appealing the action of the zoning administrator, which denied an overheight fence in CD5. And Mr. Brown is here. Oh.
Good afternoon, sir.
Good afternoon. Point of clarification. I just wanted to clarify the motion that was put forth for this item. There's been discussion just as far as the ambiguity of it. Just to make clear that the motion was put forward with regards to the applicant,
Do you mind just for the record reintroduce yourself?
Oh, I'm sorry. Sean Bayless, Planning Deputy for Councilmember Paul Koretz. And
Okay.
just wanted to clarify for the record that the Area Planning Commission denied the appeal and sustained the previous zoning administrator's decision in this case. I just want to clarify that that's what everyone understands to be true.
Okay.
Okay.
All right. Thank you for that. So, good afternoon, sir.
Good afternoon, Nicholas Brown, Associate Zoning Administrator.
Please, to give us your report.
There are some materials that have been handed out. You do have the color version of photographs. I did make also black and whites. I did leave them on the second row to my right if there's anyone in the audience that also wish to have a copy of the materials I'm going to refer to. Those photographs are handouts that show the before and after of the property. What you see on page 1 is that you have landscape that basically screens the property, and what you see on photos 3A and 3B is what currently exists. You now have a 6-foot wall with 6 inches with pilasters that I think extend to about 7 feet 6 inches. And you also have examples of 38 properties that are in the area, and those 38 properties are those that are on both sides of the block that to a large degree define the area. There were 3 reasons why I denied this case. One is that the wall is out of scale with the site. As you look at the wall, what becomes predominant view is the wall, and that is because the house behind it is only 1 story and does have a decline slightly, and the street is higher. The other is that as you look at the wall, you can see that it's very close to the street. It's only 6 inches from the curb. For those reasons, and the fact that it has no sidewalk or open space in front of it, that wall dominates the view. The other is that it's out of scale with the surroundings, and the photographs do show that there are approximately 14 other properties that have over-the-height walls, fences, or hedges. However, those are very different, and this project is not compatible. Some of the defining features that you see in those other properties is that they have landscape in front of or behind the wall or the fence that actually soften the appearance of that over-the-height structure. Also, the house is more in scale. Some of the houses sit up higher, and therefore the wall or fence or the landscape is not the predominant view. The other is that there's a sidewalk or that structure is set back. And also, many of those are not solid, such as in this case. The last reason that I denied this case is because it's out of context with an approval that we previously made. Right across the street from this property is an over-the-height wall, but there are significant differences between that we approved and this. Some of the differences are that is a retaining wall, and as it extends, there is nothing behind it. However, the higher part of that wall was necessary because there was a 3.5 foot wall that allowed individuals to step on it and then step onto the garage of the house, and therefore what was necessary was to raise the height of that wall. Some of the other differences in that approval and this is that it's more in scale because it's set back, it has a sidewalk in front of it. It also is more open. And it is safer also because in that case, individuals who park on the street, the passenger can open the door. In this case, because the wall is right next to the street, a passenger cannot open the door, and people tend to park out into the street in a situation like that. Also, there were very few options in that other case. They had to have a retaining wall to hold back the soil. That's not in this case. There were other options that could have been used to provide what they needed. And lastly, the other case, the one that we approved, is not on city property. When I became a zoning administrator some years back, I remember Frank Eberhardt, the then deputy director of the department, saying something to me in a way of advice. He said, you know, when you have conflicting interests and you have the potential for impacts, the first thing you want to try to do is to reduce the harm. If you go to page 8 of my determination, you will see that I did offer some suggestions of how the harm, visual harm, safety, could be dealt with. However, after the public hearing, and I took a closer look at the evidence that was in front of me, as well as at my additional research, I realized that that was not enough, and that I could not reconcile the issues in this case. One is that there was a limited amount of mitigation I can do to try to make this compatible with the surrounding. Another is that it is on city property, and I did discuss this with the Bureau of Engineering, and they say they are disinclined to approve such a structure on city property. And also, there was opposition from the community, who have said that they do not wish for this applicant to use the many illegal walls, fences, and hedges in their community to be the grounds for approval of this case. And for those reasons, it led me to a denial. Are there any questions at this time?
Well, when we talk about the city property in which this wall has been built, does that easement have a functional role for the street?
Yes.
In terms of infrastructure? Can you describe that?
Underneath the wall are the conduits and the wiring for the street lights. And in fact, if there may not be my photographs, but there are photographs that show a slight cutout in the wall, and that's because there is actually a service box at that location. If you go to the end of the wall, they also cut it out so that the actual light standard and the box were not were worked around, but underneath that is where the easement is, and yes, it is functional.
So the power lines are underneath?
For the lighting, yes.
So the assumption is the foundations are either not deep enough or the power lines are very deep?
I have no assessment of that. I have to discuss that with building and safety, understand how it's actually designed.
So do you have any idea of the structural integrity of that wall if we
None.
don't know how deep or how shallow it is?
None.
Wow. That's what's illegal, right?
Well, yes, if they would have gone in and filed for a building permit, and building and safety would have looked and ensured that it was built to code and would have come out at different stages of its construction and made sure that it met code. But I have no information on that matter. No, I don't know.
We don't have a structural engineering, anything that talks about
Nothing was submitted to the administrative record on that matter.
All right. Anything else you'd like to add, or any questions for Mr. Brown? Okay. Yes, ma'am.
Terry Kaufman, Macias City Attorney's Office. So depending on, after hearing the comments from the public, there are special findings that you have to make if you want to overturn the zoning administrator, because you now stand in the shoes of the APC, because this is a 245. and you have to base your decision on the evidence before the ZA and the record findings and decision of the ZA. So if you get to that point and you want me to elaborate further, I can do that.
But it's a yes or no based on findings.
You have to make written, if you disagree with the zoning administrator, you have to make written findings specifically setting forth the manner in which you believe the action of the zoning administrator was in error or constituted an abuse of discretion.
Okay. So at this time, we should be hearing from the applicant?
The appellant.
The appellant. And that'd be the council office.
No, actually, there's an appeal filed by Joe and Orrit Picker.
Like to come on up? Good afternoon, sir.
Good afternoon, Chairman. My name is Jim Marquez, and my address is at 796 West 27th Street in San Pedro. I'm here today as the representative for the owners Joe and Orrit Picker, who are appealing a case that was denied by a zoning administrator, and then that denial was upheld by the Area Planning Commission. What I'd like to do is focus on first the physical side of what we have here on the property. We have a downward sloping hillside road called Deer Vale Drive that slopes to the north at a 10% slope. And the owners have built a block wall 6 feet in height for the panel, maybe a little less, and 7 pilasters, a 24-foot wide gate would be placed at the driveway, and 2 pilasters in the right end for a man gate on the north end. What we have, the wall's styling incorporates careful use of color, texture, considerate construction materials, as suggested for the walls that were approved on the property directly across the street at 350 Deer Vale some time ago. The site photos show that you've got in your package from our office show that the existing wall with the owners securing star jasmine vines were placed so they cascade over the tops of the panels. This was done as one of those suggestions that Mr. Brown mentioned were in the staff report. So she thought positive that he had told her at the hearing that he wasn't going to require the wall to be removed. That happened when he was in deliberation. So she took it upon herself to put something in that matched the other landscape materials they have on the property, and it looks quite nice. You have 3 pages of photographs from my office that were submitted to you this morning. I have extras if you so wish. Does everyone have a copy of this? Okay.
This is bizarre.
The bottom part of this exhibit shows the front property line and the fence located basically over the front property line at the curb a few inches back from the face of the curb. Now, the safety issue that Mr. Brown brought up was that it's unsafe to have a wall this close to the curb. However, the photographs show that this is the way walls have been built throughout this hillside area, number one. Number two, for those that have been built, the Public Works Department has never come out and cited them or made them remove them. Otherwise, the character of the hillside would look considerably different today. We measure the distance between the curb face itself, and we find it's about 6 inches higher than the ground. The width of it is 6 inches. The wall being back 6 places the wall at a safe enough distance for someone to park a car 18 inches from the curb with enough room for the door to be opened, a passenger could get out, and not be parked within the street itself. So there really is no safety issue here, which is an item we would be discussing and bringing forth to your Public Works Commission when we file for a revocable permit, which is the order in which this case was understood to be processed. One, they received a violation for building the wall without a permit from Building and Safety. Building and Safety advised them they need clearance from planning and from Public Works. And when we went to planning and we talked to them, and I came into this after the fact. I was brought in at the appeal stage, not in the beginning. But I learned that the order in which they were to seek compliance was first to go to city planning, gain approval for the height of the wall. As the gentleman earlier in the prior case mentioned, zoning goes all the way to the center line of the street. So therefore, everything in that entire area has to be heard by planning first. They have jurisdiction. And then when they've concluded whether the wall should be allowed at the height that they are requesting it within the front area, then it would be their responsibility to go and file an application with the Board of Public Works for a revocable permit. For the zoning administrator to stand in between there and suggest that the Public Works Department, even though he talked to them, this came about after the hearing, he talked with them separately from the owner's awareness. He made the conclusion that Public Works wouldn't want it, but it's not a verbal decision that a staff engineer can make, because encroachments under revocable permit go before a board such as yours, where there's a public hearing and there's input on both sides. So what we ended up with was a decision that pulled away the owner's opportunity to make establishment on the wall itself, the height, then go before the Board of Public Works to decide whether they can remain there and deal with the issues of the underground wires and the location adjacent to the curb and those safety issues. So what I'm asking your board to look at first is the wall in its architectural character the type and style of wall that would be fitting for this neighborhood? And by the inclusion of these cutouts, which we would call landscape viewports, so you could see landscaping behind them, just as you did for the fencing that was approved across the street and some others in the neighborhood. We can have now more landscaping that could even cascade from this point, but could be seen from the street.
Excuse me, sir. Would it be, so the process by which you have followed seems to be a little out of order, and you still run the risk, I'm assuming,
That's right,
that Public Works could still deny this permit, and that the wall would have to come down as a result, given the functional element that exists currently underground. Would that be accurate?
That's very accurate. The functional element really is threefold. Number one, because their property has a descending slope from the roadway down, they can't, and their house is only 10 feet 11 inches from the curb line itself. They have a prevailing setback of just under 11 feet for this neighborhood on this side of the street. There's no room to put a fence or a wall down at that lower level. If you do, because it's 6 or 7 feet down by where the windows are to the bedrooms, you can still look down over the wall and see into the rooms. So they do not get the same enjoyment of safety and privacy that their neighbors get.
Okay. All right. Could you conclude your presentation? Because we do have quite a few cards, and you are the appellant, so we want to make sure you conclude.
The most important, the element that I'm bringing to you here is that there is architectural consideration to replicate what the elements of design that have been conditioned into previous cases in the neighborhood. This is the effect that we've discussed with the council office, and we feel does mirror the character that has been previously conditioned for this area. I'm now going to turn over the microphone to Fred Gaines, the applicant's attorney, to describe the findings and make additional comments. Thank you.
Thank you, Mr. Chairman, honorable committee members. Fred Gaines of the Law Offices of Gaines and Stacy on behalf of Joe and Arit Picker. And we're appreciative, of course, to Councilman Koretz, Councilman Zine for making the motion to bring this matter before the committee and the vote of the council to do that. In order for you to make the decision to grant this approval, you'll need to make a set of findings. And I have provided to you a document where I've included a proposed set of findings that go into detail to the exact findings that need to be made in this case. I've also included proposed conditions of approval, and I think this goes to some of the issues that the chairman was raising. And then finally, under Exhibit C, you'll see some color photos of the wall, and then of the walls immediately on all the immediate adjacent properties and others on that block. We do believe that, I'm going to refer to it in 1 second. Is that all right?
Thank you, Sarge. I appreciate that.
And,
is that
and
a hint?
you
Is
have
that a hint, Sarge?
You have a version of that in front of you. There are four places where we would ask that you review this and find that there's been an error made. First of all, one of the reasons given for the denial was that the wall is constructed in the right-of-way. In the conditions of approval that we propose, it would require that we obtain any necessary permits, both the building permits, and if that requires them to show the foundations and show the structural integrity, they'll have to do that. But also with regard to the encroachment, that's the process you would normally go through. You would not have one department make a predetermination for another department, the Department of Public Works, as to whether or not that can or can't be done. You would allow the applicant to go through the process of obtaining the necessary permits. So it's important, if you decide to approve this, that the conditions of approval that we've proposed, which require that they obtain all building permits, require that they obtain all encroachment permits. If they're unable to do that, that is how you answer that question. So if they're unable to do that, then they would be unable to continue to maintain the wall, or they'd have to move it if in fact and I'll be honest, I don't know whether it's on top of the electrical wires or not, but they would have to go through the normal process of proving that, and that is what we've put into the conditions of approval. Error number 2 has to do with compatibility with the neighborhood. You're being asked to make a finding that there's not compatibility with the neighborhood. If you look at the photos of the dozens of walls in this area, including immediately next door and 2 immediately across the street, it's impossible, frankly, to make that compatibility finding, particularly in the case where, at the request of Councilman Koretz, in a way of compromise, we're proposing to, and again through the conditions of approval, to have the wall be pursuant to Exhibit A. Exhibit A would be this revised wall, which would make large openings in the wall with hot iron grading. So instead of a solid wall, we're talking about 6 different 8-foot, 8.5-foot long openings to open up the wall, which was one of the criticisms of the design. And so we're proposing this revised design, and which makes it more compatible with the walls that are already existing. And we provided you the photos. The third is with the uniqueness of the property. What I wanted you to see here is, this is actually a wall on the side of the house. The front door is here. You're driving in the front door. The reason that this wall is so necessary for protection, normally the house faces the street, you have a front door, you have 2 gates on the side, and you're enclosed. If you did that, if you have a 3.5-foot wall along this edge here, the entire side of the house into the backyard has only a 3.5-foot fence. That's the uniqueness of this particular property, because the house doesn't face the street, it faces on the side. And that's exactly why you allow exceptions in these walls. Side walls are normally allowed to be 6 feet. In this case, it's 6 feet. Finally, it's important I make a couple more points. The last is the evidence of the nuisance in this case. There's been evidence of criminal activity on the site. It is a house next door to a movie star where there are constant paparazzi incidents on the site. And the evidence in the record, when you go back to the zoning administrator's own decision, you will find the actual references. In the decision, the statements are made, so the facts are there. Staff observed numerous over in height fences and yards in the neighborhood, including with columns for lights fixtures on page 4.
Mr. Gaines, I need you to wrap up because we have a lot of cards.
So then I'll summarize by saying if you go to page 4, 5, 6, 7 of the zoning ministry, you'll find the actual facts that support these issues regarding right-of-way, compatibility, uniqueness of the property, the evidence of the nuisance that support you making a decision in this case.
Thank you very much.
And I appreciate the time. Thank you so much.
You're welcome. Okay, so we covered the principals, the appellants, the applicant. So let's go through the cards. I'll call your name, give us your name and address. If the speaker before you has made your statement, it's okay to say I agree with the previous speaker. give us anything new and or different, so that way we can assess the case and not repeat the same thing over and over again. So that being said, come on up. Some of you have written eloquent letters. Hope you keep your eye on the clock so you can get to your point. Sometimes you go through one quarter of the letter and you run out of time and you didn't make your point. So let's try to get to your point as soon as you can. Okay, so let's dig in. We have Nancy Krupa, Josephine Lazaridis, I believe, and Alk Heitmeyer. Like to come on up? Nancy Krupa, Josephine Lazaridis. You can form a line if you'd like. Ms. Heitmeyer. So I have three speakers, Nancy Krupa, Josephine Lazaridis. I apologize if I'm not pronouncing your name right. Good afternoon, ma'am.
Yeah, my name is Nancy Krupa. I live.
Would you mind speaking into the microphone?
My name is Nancy Krupa. I live at 14676 Deervale Place, Sherman Oaks.
Good afternoon,
and what
ma'am.
I brought here is pictures for the three of you to look at. There's an 8x10 in each one of these that has a diagram of the street, and it has each one of the addresses on it. And then I have a package of pictures in each one of them that has one picture for each parcel on the street. So you can see what the street really looks like in lieu of driving down it. The South Valley Planning Commission members drove the street, and they actually saw the neighborhood, and that influenced their decision. Okay. From those pictures, you'll see there are many houses with no walls or fences at all in front of them. Most of the walls on the street are retaining walls, okay, not privacy walls. There are only a very few privacy walls. The privacy walls on our street are all lower than this wall. They're set back from the street, and they're landscaped. From the pictures, you can see that this wall is not necessary because the property next door that belongs to the celebrity has essentially the same topography. What he put in was a fence behind the hedge that it meets code and is legal. So there are plenty of other options for these people to have been able to protect their property from their paparazzis. What we're concerned about in the neighborhood is property values. If this wall is approved, it will set a new precedent for the whole neighborhood that will allow these types of walls to go in all up and down gradually, parcel by parcel, up and down the street. We currently have open street, lots of greenery with walls all the way down the street. It'll just turn into a barren walled canyon.
Can you conclude, ma'am?
Huh?
Finish your point?
One more point I wanted to make
Please.
is the approval of this would send the wrong message to the populace.
Okay, we heard that. Okay, thank you very much, ma'am. Next speaker? Good afternoon, ma'am.
Good afternoon. My name is Josephine Lazaridis. I live at 4001 Deervale Drive. We live north of the property, and in between our house and the applicant's house is the celebrity. Initially, we did have some concerns about the paparazzi, not because we were concerned for our safety, but because we were concerned that they would come in the morning and somehow they would find out when he was in town. When he was out of town, there would be no paparazzi. The minute he landed at the airport, they were there within 30 minutes. They would park their cars, hang around the cars, they would leave their fast food debris and their cigarettes on the street. We live in the hills. We're always concerned about people smoking and discarding of their cigarettes, into the area. Initially, when we went to the Planning Commission in Van Nuys, the applicant was concerned about animals in the area, that they had a small dog and that they didn't want the dog harmed by coyotes and animals. So the gentleman who was in charge of the Planning Commission asked them that you bought a house in the mountains of the Santa Monica Hills on a street called Deervale. You should have considered, wildlife initially before you purchase this house. So now the issue has become that the reason that the wall was erected was for paparazzi. And we're not concerned about the security of being harmed by paparazzi. That was not our issue. Thank you.
Thank you, ma'am. Elke Heidmeyer?
Elke Heidmeyer, yes. I am a neighbor, and I also speak on behalf of the Sherman Oaks Homeowners Association that I'm on the board of. I submitted pictures just so you can see the property across the way that they are referring to is indeed a retaining wall, and just for good measure, some beautiful pictures of our beautiful street. You also have included a letter by the previous owner of the property indicating that she felt perfectly safe with that beautiful ficus hedge that she had, and her bathroom window didn't even need a curtain. She also submitted a letter, the bathroom window that faces the street. She felt the privacy was secured by the ficus hedge that was there before. She also submitted a letter in your package indicating that she did not have any problems with paparazzi in the year that she lived next to the celebrity. I wanted to point out that over a year ago, the Building and Safety issued a notice to comply stating the code violations. The zoning administrator very thoroughly had 2 hearings and denied the application for this wall. The Planning Commission had a very extensive hearing and denied the application for the wall. And now we're here because some city council members feel a need to override the bodies who have the jurisdiction and the responsibility to watch out for the rules in this city to be observed, and there are rules that would allow exemptions. As was pointed out, several of the homes on our street have exemptions, and these bodies that are responsible for upholding the regulations should be allowed to perform their work.
Thank you, ma'am. Steve Lazaridis, then Aaron Laura, I believe.
Yes. Good afternoon. My name is Steve Lazaridis. I live 2 houses down at 4001 Deerville. The issue that we have basically is that the concern is that the wall was not built with a permit, and we do not know how it was built. We do not know if there's a decent foundation for the wall. I have some pictures of the bottom that we have a concern that maybe the foundation is not deep enough. We also have the height of the wall, which is also an issue that if we have an earthquake in the neighborhood and the wall were to fall, if someone would be walking or a car would be parked there, obviously they would get hurt or killed. Don't know what would come first. But I also have a couple of pictures of me standing on a ladder of the height, so you kind of have an idea. I'm 6 feet tall. I'm on a 3-foot ladder when I took the picture. My head is just about even with the top of the light fixture. Oh, sorry. The wall is also built around the water main, and I think they have an issue with the Department of Water and Power that if they come out to read the meter, I don't know if they can get the cover open. They built the wall right around the meter, and I think they have an issue with it. Also, Lighting Bureau, the wall is built 2 inches from the curb. Since it's built right there, we have a lighting problem on our street where the street lights go out when it rains really heavily. We have fuses that pop, and when they pop, they come out, they have to fix it. One day they would like to get that addressed, but when, I don't know. But it is an issue of where it's at.
Thank you, sir.
Can I make one more point?
Can you just finish?
Okay. We had a fire on the street a couple months ago, and when the fire department did come, they were not able to park on that side due to the fact that the wall was so close. They had to kind of park more towards the center. They did call park enforcement to close the street down.
Thank you, sir.
Thank you
very much. Next speaker.
Mr. Chairman, members of the board, my name is Aaron Lohr. I have lived at 4053 Deervale Drive since August 15, 1972, over 39 years. I raised 4 boys in that house. 2 went to St. Cyril's Elementary School. 2 went to Notre Dame, went on to UCLA and USC. During this time, people have moved in and out of the neighborhood. Some have done beautiful things to their property, some have not. We have considered moving several times over the years, but frankly, we could not find any area as nice as Deervale Drive. We have deer, coyotes, possums, skunks, and bobcats, yet we are minutes from Ventura Boulevard. I am 81 years old, and my wife is 71. We intend to spend the twilight of our life on Deervale Drive. After we're gone, I suspect one of our 4 sons will move into the house. I mention all this because I would never, ever do anything to detract or support anything that I believe would diminish the beauty of the street. It truly is a wonderful place to live, and we consider ourselves most fortunate to be living there. With respect to Mr. Pickles' wall, I understand he did not comply with the city building code. For the last 18 years of my career, I was the Deputy Director and Chief Operating Officer of the UCLA Medical Center, and as such had numerous dealings with the Office of Statewide Health Planning and Development, also known as OSHPD. So I do know something about code compliance. Accordingly, I am not here to defend Mr. Pickles' violation of the building code. I am also aware of the slippery slope argument. That is, if you make one exception for Mr. Pickles, what's next? Where do we draw the line? However, I would remind you that within 1 mile radius of the house, I counted about 10 walls that were built right up to the curb. I personally like the wall, but obviously beauty is in the eyes of the beholder. My final comment is this. We all live in difficult economic times, and I think it would be criminal to force Mr. Pickles to spend thousands and thousands of dollars unnecessarily to tear down this wall, and I would hope that your committee could come up with a compromise.
Thank you very much. Kathy Raffetti, I believe. I apologize, I mispronounced. Kat.
Not at all, no problem. My name is Kathy Raffaelli. I'm a friend of Orit and Joe Picker. Just want to bring to the attention of around April 25th, if I remember, Orit called me to tell me that Mr. Brown gave her the oral approval for the wall. And he told her that he's not going to bring it down. And he also suggested to get plants and high plants. And me and her, we went the next day. We have even receipt to prove that on the date. On the 26th, I took a pickup truck for my dealership, and then we went over and we bought a lot of plants to cover. Everybody's talking about that the wall is not, it's bare. Give it some time. We have so many plants there that's going to be covered at his suggestion. Thank you.
Thank you, ma'am. Kat Kick? Kat Kick, are you here? And Ryan Kick, then we'll have Jim Weston.
Hello, and thank you for this opportunity to speak. I am Joe and Orit's daughter, and something that is kind of embarrassing, but when I was 16, before I even had the opportunity to get a driver's license, my father dropped me off at comedy traffic school and had me sit through 8 hours of nonsense, in my opinion, so that I would not make a mistake, so that I would be safe on the roads when I was old enough to drive on my own, because he couldn't be there to protect me. My father's primary concern my entire life has been keeping his family safe. And as a result, when we moved into this home, which we felt so fortunate to be a part of this new community, we kind of soon realized that we were not always comfortable, because the door did not face the street, because you didn't know who was entering, and soon after, because there was actually criminal activity in the home, around the home. And as a result, my father's first instinct was just to do something to protect his family, which I think anybody here would do. And unfortunately, the problem with permits is that you don't sometimes know you need one until it's a little bit too late. And honestly, that is a mistake our family has learned and paid for. But I really want it to be known that my father's primary concern is to make sure that his family and my soon-to-be-born nephew and my soon-to-be-born, grandchildren of his to be safe, to play together with our 5 small dogs, and really to just not have to worry about being harassed by anything from coyotes to paparazzi to neighbors who in this room have actually verbally assaulted my mother. And, just general things like that. And at this point, it's a safety concern, but also something you should know about my mother is that she would never do anything to devalue this home, which is so important to her, which she expects to be the last home that she lives in and to one day pass on to her children. And this wall is really tasteful and beautiful, and the jasmine that she has chosen to put on it is also beautiful as well.
Thank you very much.
Thank you for the opportunity.
Thank you for your time. Ryan Kick? Then Jimmy Question.
Brian Kick, 1375 Kelton Avenue. Thank you. I'm here also to speak for Joe and Orit, and if you're coming out to defend your in-laws, it's something you probably feel pretty good about yourself. And it's because I've house sat at that home. I've been there when there were just the bushes in front, and when you're in the living room and far below the street level, and you can see people walk by who choose not to use the curb on the other side of the street, but to walk right along the property line. They're able to easily look down into the living room. Animals can easily come through the bushes that were there, and it's frightening. It's a little bit scary out there. I mean, I'm not trying to make it sound like it's terrifying by any stretch, but you do worry about what's going to happen while you're there in the home and when you're there with your wife, and you can hear and see that people can easily look down upon you, but you can't with them. And respectfully to some of the things that Mr. Brown had mentioned as differences between the properties, I think it is the fact that the house sits below the street level is why the wall is necessary. Because if an intruder was to walk onto their property before the wall was there, no neighbor would ever see it. That intruder would immediately fall below eye level, and that no neighbor would have any idea someone was on their property. Whereas any of the neighboring homes, being above street level, we're able to keep an eye on and make sure we look out for each other. That's not something that you can do at this home now. And I have pulled out of that home. I have seen coyotes run through the bushes before the wall was there. It is something that you want to be aware of. I do feel that it's actually the circumstances of this wall with its long side exposure and its lower than street level location that actually makes the wall so necessary. Having been there since, I do know that you no longer feel or see those eyes coming in on you when you are sitting in the home because the wall is there. I do think that they have always gone above and beyond to be a part of a community. I don't think the wall was put up to distance themselves in any way, any form at all. Instead, it was there to simply make their family, my wife who spoke earlier, just feel more comfortable. And I think that's the true intention, and I hope that's what everyone recognizes. Thank you.
Thank you, sir. Mr. McQuiston. Then we'll have Cherry Schroeder, and then we'll have Dr. Peggy Weiner, and that should conclude. Good afternoon.
Jim McQuiston. A police officer told me once that when he was living in Compton, they thought they needed a high wall to protect themselves, and they found out the police statistics say that there's more crime behind high walls than low walls. The reason that we have that in our zoning code is because a policeman sitting in a car cannot see above a wall that's higher than 3 foot 6 inches. And that is a public safety reason for having it. Otherwise, we couldn't control the height of walls because there's no public safety reason for having it. But 3 foot 6 is the reason. And those people who think that a high wall protects them are living in a fool's paradise. The crime rate is higher behind a high wall than it is behind a low wall.
Thank you, Mr. Christen. Schroeder, please.
Yeah, I'm friends with the Pickers, and I just wanted to state that I think that these people are being singled out unfairly because several different things. There's many neighbors who don't have permits. So why are these people being singled out? Are they going to anybody else's prior owners and having them define for them what's supposed to be comfortable for them? And the one gentleman said he doesn't know whether the thing is safe. He just assumes that it's not safe. Is he asking for an inspection? Is he asking why? Is he asking if it's safe? No, these people are being singled out and targeted by some of their neighbors, and I just think that's unfair.
Thank you, ma'am. Next speaker, please.
Am I up next?
Yes.
Okay. My name is Dr. Peggy Weiner. I've been in the neighborhood for 35 years. It is a hillside neighborhood. I don't want to repeat what a lot of people have said, but in a hillside neighborhood, you do not have cookie-cutter homes. I have known Orit before she built this wall, and the house doesn't look anything close to what it does today. It is absolutely beautiful, the wall. The aesthetics exist. As far as the wall being sturdy and appropriate, somebody needs to do their research. My husband's a contractor. He's more than willing to go in, fill out paperwork after he inspects the place. These walls are 3 feet deep. They have rebarb, and this can be proven. As far as the 3'6" information you just got, that only applies to the front of a house. You can have 6 feet walls going all the way around the perimeter of a property. And this is a wall that was built with beautiful, tasteful planning. This is an eclectic neighborhood. We have walls of all kinds of sizes in our neighborhood. There is a protection factor. We are in a high-profile neighborhood with lots of paparazzi. I have it going on in my neighborhood. There are celebrities living there, regular people like us living there, and therefore I do understand when people want to put walls up to give themselves a privacy factor. There is a lot of robberies. There is a lot of crime that can go on in these neighborhoods. It's a very opportunistic, challenging neighborhood where people can impose on us, and we want to feel safe. Again, we are not in a cookie-cutter neighborhood, not that there's anything wrong with cookie-cutter neighborhoods, but we've chosen to live in the hills. I have 3 little dogs. I'm not worried about their safety because I have enclosed my property as well, and I keep an eye on everything. But I do worry about intruders, and I think the Pickers have been nothing but honest and very tasteful and considerate about making the neighborhood beautiful.
Thank you, ma'am. I did find a call from Mr. Joe Picker, but not a red, but I'd like to call them up if they felt I have not asked them to come on up. Come on up.
Good afternoon.
Good afternoon, sir. And you are?
Joe Picker.
Joe Picker, okay.
3951 Deervale.
Good afternoon, sir.
First, a few comments about the structure of the building. It's about 3 foot deep, about 24 inches wide. It has 716 rebar. It has, compared to 316 that you need, all the blocks are 10 inches, and they're all full of concrete. You don't have to fill in by law any second one. I'm welcome anybody to check it, and we will do. As far as not being able to open the door, most of the homes that do not have walls around us, they have a chain link. The chain link actually, it doesn't go about 3 or 4 inches or 5 inches from the sidewalk or from the curb. They actually instead of the curb. And if you drive and you no way you can open your door ever. And even if they do not have a chain link and they have ficus or other vegetation and it's overflow to the street, which most of them do, how are you going to open the door, even if it's not a block wall? So that's, I don't think that I have any ground. We did not plan to. This is Steve House, the person that steered the whole thing. That's how you look. By the way, this wrought iron fence does not have permit. And he talks about the height of our wall. This is me in front of the wall. I'm about 5'10". Yeah, you can say about 1 inch taller. It's not exactly so. That's about the size, the height of the wall, 5'11". And the vegetation that you see, it just will get better and better and better. As soon as we got Mr. Brown's decision that he said he's going to approve our wall with slight changes, like put bougainvillea or other plants, immediately we went and bought like 15 gallon jasmine and put them on, so they start to grow and start to cover the wall and look good. All we want is to live, to be safe in our own home. My wife does not feel safe. I volunteer work that I used to do, I had to stop. We have paparazzi that because we live right above Shaya. We are not in the same position that they are below Shaya. And people, paparazzi and people just walk in our front yard and our back.
Mr. Pickett, just another question from Councilman Bozard.
I have one simple question. So when you decided to build the wall, why didn't you take out the hedge, put the wall where the hedge was, and respect property, your private property and public property lines?
First of all, we consulted with a few contractors before we started the construction. And the first question we asked was, is it legal to go ahead and do it? Do we need permit? All three contractors told us that we do not need permit. They all said they did work in the area, they built everything in this area, and they never asked for permit.
So it's your contractors?
The contractors.
But there was some public space there, I assume, that people would walk through, I'm looking at this, it looks like a typical public sidewalk that you would assume it's public right away.
There is no sidewalk on our side. The sidewalk is on the other side. Our side did not have sidewalk. Actually, we are right now farther from the curb than before. Okay. Before the ficus was overflow to the street.
So the mistake, you say it was your contractor's mistake?
Ultimately, it's my mistake. But the contractors told us, we asked the contractors, they say, you do not need permit. We love being citizens. We never did anything without permit.
Okay, and you didn't bother to find where was the actual public and private line, wherever needed?
If you take a look or drive on our street and the streets around.
Easement?
You hire those guys. I'm sorry, go ahead.
If you drive around our street, you'll see there are many properties. They have wall, not retaining wall, that is on the curb, just touching the curb. We assume that if that's the normal, we did not know. We just did not know what to ask. We just saw that that's what's going on. We assumed the same. If three contractors say it's okay, we assume they know what they're talking about. And seeing also other houses that have a similar situation, with the fences go all the way to the curb. So we just assume that that's the way it is.
And there's other homes on your block where there's walls that come out this far?
Yeah, on the next street. Yeah.
Okay.
Yes. Closer than us, closer than ours to the street.
Okay.
Thank you.
Ms. Pickett, did you want to say anything else?
I just want to add, I had a big speech, but because of the paparazzi and the intruders, that it's nice to live next to a celebrity like Shia LaBeouf, but there is pain come with it. We did not know that. People walked in day and night. Our dogs used to bark. We didn't know what's going on. So we decided to build the wall that we did not have the money for, just to protect ourselves. And when Mr. Brown told us he's going to approve it, we bought the jasmine to beautify the place, and we waited for him to give us the last detail how to make it even more beautiful. And then we got the shock when we got a letter that say that we better find a guard dog and security company to protect ourselves. So we did not think that was what we talked about.
Thank you, Mr. Picker. Thank you, Mrs. Picker. Did you want to say anything? No, thank you.
I just want to thank you all for listening to us.
Okay.
I apologize that I have to take your, such a time for our small matter, but it's really, affect our life tremendously. Thank you.
Thank you, Ms. Picker. Okay, so Mr. Brown would like to come on up to the microphone. when one of the comments that I heard from Mr. Gaines and the representatives is that they are requesting that part of the conditions is for the property owners to go through the process of Public Works and go through the permitting process to see if that wall can remain, and it would essentially abide by any conditions that might come up in their process as a way to address the inconsistencies and or the lack of order that we typically follow when walls like this are being built. Is that, how do you respond to that?
Well, I do wish to note that that wasn't the only issue in ruling a denial, and it is understood that it is the process. What I mentioned earlier, and that's in the written record, is I spoke with the Bureau of Engineering, and they said that they're not inclined to. But again, that is not the only reason that I denied the case, but that is the process.
No, I understand
Same
that.
thing with building safety.
I'm not saying that was the only reason. I was asking a question about that process.
That is the process.
Okay, and I want to get your reaction to it, but you're saying you already spoke to Bureau of Engineering, and they're not inclined, but they still have the right to try to achieve the permit, correct?
Yes, that's correct.
Okay. Now, what other salient points you think we should know that is based on your observations on this?
Well, I would like to suggest that I can respond to your questions, but I do want something to be very clear for the record, and it is found on page 6. I did not tell them that I will approve this case at the public hearing.
Well, that was my next question.
That what I said is that I was leaning towards approval and that I needed to do further research. I took it under advisement. And with that additional research, it led me to the conclusion of a denial.
Okay. Okay. Any questions, Mr. Brown? Because I was going to ask the council office to come on up, but we can ask.
I was going to ask about this picture we received. I'm not sure if you've seen it. I think this is a picture of a DWP meter underneath the...
I will need to see that.
One of the public speakers brought this up. Are there any regulations as to how much space there should be around that meter? I assume it's a meter. I can't. Is it a meter?
Yes, that's the water meter. And
that's the water meter. Okay.
Yeah. And I don't know what the requirements are.
You don't know what the requirements are, or if there's any codes that need to be followed when you build around that water meter, correct?
That would be building and safety that would be able to answer that question, but I do not have that information.
But should have they gone through the regular process and getting the permit beforehand, they would have known if this was built.
Well, if they would have come to the building department, they would have understood the requirements for building the wall. Yes. You are looking at the water main. By the way, there is also a cutout for the electrical, and I'm sure that's probably one of the photos too, but that is what our building and safety is there for when you come to them and ask, what can I do to ensure I am meeting the requirements of the code?
Okay, thank you.
Councilman?
Mr. Brown, there's seems to be, at least I'm confused about some of the facts because there seems to be a disagreement. I heard the pickers to say that there were a number of other properties on their street, on their block, that had fences that were on the curb. And yet I have a packet of photographs here, and we heard the statement of other neighbors that said that there were no walls on Deervale, on their street, that went up to the curb. There are some in the surrounding neighborhood, apparently, and on other streets, and I think there were photographs submitted by their representative that showed that there were, on surrounding streets, there were some such walls. What is the reality between those two conflicting views, or am I missing something between the two positions?
I think that if you go to...
Terry Coughlin, the City Attorney's Office, you may want to take a break until Mr. Reyes comes back.
He took a 2-minute break. Do we need them in the room?
You know, just because it's quasi-judicial and you're still hearing some testimony and facts.
Okay. Why don't we do this? As the vice chair right now, chairing this meeting, I'd ask that we do a 5-minute break if we could, and come back and reconvene in 5 minutes. Okay. Thank you.
It's not true now.
Okay. Thank you, Sarge.
What am I doing?
I believe the council deputy wanted to speak. It's Mr. Brown, I think. Did we finish with the questions with Mr. Brown?
I was asked a question.
Okay, well, let's finish the questions then.
And what I did submit for the record are photographs of every single property that is on the block face and across the street, so you can see for yourself what there is. You tend to see, and it was stated earlier by someone else, that the walls are on the other side of the street, and they're retaining walls. What, however, is a benefit is that there is a sidewalk that is on the other side of the street. There are a few high structures, and there's, I think, 6, 7, 9, and 10 in the photographs that show you that there are walls and landscape, but I meant to say landscape and fencing. However, you don't see a wall similar to what is on this subject property. I was just shown some photographs that were submitted to you by the applicant, appellant, property owner, and many of those photographs that I see there, as well as some of the others that are there, are not on this street. So this is the official record that I submitted to you of what is on the street, and that is all I know about the over and the height fences on both sides.
Mr. Brown, just one last question. When the owner mentioned that the contractor was following the line in how they built the wall based on whatever else was doing, is there in numbers 12 and 14, is that, you think, what they were referring to? Is it those walls?
12 and 14, the properties that are adjoining this one do not have walls, if that's what you're asking.
Yeah, because I was trying to understand the logic of how the wall came up. They were saying it's because it matches the other lines.
No, the properties that adjoin this one do not have walls. I do want to note that one of the things that I had to research was the fact that the exhibit that I had at the public hearing submitted by the applicant was not accurate. It did not show where the street was correctly, nor the easement underneath. And that was a part of the reason why I had to do additional research, is because the information, I believe, wasn't accurate from the testimony I was being told. So if you do have a plot plan, even that plot plan where it shows where the property is, that is in part actually city property.
Okay. Thank you, sir. I know the council office representative would like to speak. He's been anxiously waiting. I see him pacing back there.
I'm a natural worrier.
So do you mind just giving us your name again?
Sure. Sean Bayless, planning deputy for Councilmember Paul Koretz. We became aware of this issue after the zoning administrator's hearing.
After the zoning administrator?
Yes, after the ZA's hearing. And started to look at the issue and what was taking place, what would happen after that point, what happened prior to that point. After the Area Planning Commission's hearing, the council member and myself went up to the neighborhood to kind of look at the neighborhood, find out what's going on there, to give the council member a good sense of what's taking place. And what we saw were many homes that did have walls that were either in the public right-of-way or too tall, and some were both. And we saw many instances of this throughout the neighborhood. The council member takes very serious the idea of public safety. He has not shied away from in the past of making people rip things out when they've asked for variances, especially after the fact. Something I think that needs to be pointed out and highlighted is that in the process that would lay before us, should you decide to approve, is that approving this does not mean they don't have to get a building and safety permit. They still have to do that. And if building and safety says you need to open this wall up or you need to dig down and show something, they've got to do that. In addition, with regards to the public right-of-way, they have to get a revocable permit. The city gives them all the time. Restaurant wants an outdoor patio. They want restaurant space and seating out on a sidewalk, a cell phone tower, an electrical cabinet. It's a revocable permit. And if Public Works doesn't deem fit to give them a revocable permit, this wall goes away. What's before us is, should they have this wall and a wall of this height? Because if revocable permit isn't given and they have to take down this wall, should they then have the ability to build a wall on, a little further back at the same foot heightage? In addition to that, as the council member thought about the 245, that was one of the issues that definitely stood out, was the fact that a right-of-way issue, not a right-of-way issue, but a placement issue of this needs to be dealt with through Public Works, not through planning. Planning is there to say, is this wall appropriate? Public Works says, is the location of this wall appropriate if it's in the right-of-way? In addition, there are those that feel the wall is stark, meaning just it's large. The councilman feels that having them rip out large portions of the wall is appropriate. Those large portions are the sections that you saw. Those portions should be cut out. The wall should be brought down. Those cutouts should be put in. The articulation points should be created so that it does better fit within the neighborhood. Because there are many fences that have those kind of articulation points, meaning the downward sweeping, the cutouts and things of that nature. So we feel that taking the Public Works issue away from Public Works and turning it into a planning issue was incorrect. And we believe that putting in these articulation points by making the applicant rip out portions of the wall is appropriate and better fits within the community. We definitely can't begrudge the applicant for wanting to build a wall. They live beside someone who, depending on movie or what legal trouble they've gotten into recently, will cause a lot of attention. And we've been to the site. You can walk right onto their property and get a great view of the neighbor's backyard. And that's what everyone wants. They want to see us. They want to see him swimming. They want to see him doing whatever he's doing. And they get paid for those pictures, and they don't care whose property they have to go on to get it. And the hillsides are kind of a breeding ground and a magnet to a lot of those celebrities, and everyone has to deal with it on some level. There are many examples of walls that are either over height or in the public right-of-way or both. Right across the street, a wall has been given an over height zoning adjustment. And we don't feel that this will set a precedent. The precedent was set decades ago with many homes that have done the same thing. So we feel that knowing that it has to go through the process of both building and safety, has to get a revocable permit, that the safety will be verified, the location will be verified, and forcing them to rip out portions of the wall so it better fits within the community. We feel that's a good compromise.
So given, Madam Attorney can help me out here, this is a 245, it's a yes or no. If we do move in the direction of yes, there has to be findings to support our position.
Terry Kaufman, Macias City Attorney's Office. The committee and then the council, if they want to overturn the action of the zoning administrator, has to make written findings setting forth specifically the manner in which the action of the zoning administrator was in error or constituted an abuse of discretion, and refer to the evidence.
As I hear your presentation, I'm trying to understand the elaboration of the findings, because you're talking about process, but findings, which is in front of us, do we have any findings in front of us that you can stand on?
Our feeling is that the zoning administrator erred in taking on the jurisdiction of Public Works with regards to the placement of that wall. In addition, we feel that the wall is within the community standard. It does meet the aesthetic value of the community, that there are many examples in the community that this wall matches up to. We disagree with the zoning administrator on those points, especially that this wall doesn't fit in. So those are some of the areas that we definitely look at.
No, I understand.
Sure.
I understand the perspective, but right now we need to focus on our role in this committee and being able to stand on findings. And if Ms. Madam Attorney can help me with how we can put this in proper perspective.
Well, I just wanted to point out that procedurally, this requires a planning approval. It's a code requirement. So, the timing of which body got it first, I mean, that might have resolved differently if an application had been filed before the work was done. But there were findings that were submitted by Mr. Gaines, but they don't specifically reference the zoning administrator's determination. He did read off some pages where he felt that there were errors, and I guess he ran out of time, but that's, I think, where he was going with trying to point out specifically. And you did hear some testimony, which I guess was in Mr. Brown's report about the wall and other walls in the area. So,
well, colleagues, one direction we can take is we can allow Mr. Gaines to come back and give us his articulation of the findings as he sees them, given the language that was presented by Mr. Brown. Should we go in that direction, or we don't support the 245 and go with the staff's recommendation?
Can I just point out one other thing? If there was no CEQA clearance because there was no permit, so you have to make a recommendation for a CEQA, which I guess would be a categorical exemption.
My understanding is one of the directives would be for the applicant, the owner, to satisfy all the requirements, and if they don't, then the wall doesn't stay. Is that accurate? Mr. Gaines? So I'm trying to get...
But this committee would have to make a recommendation on that.
We don't have to?
No, if you believe that Mr. Brown erred and abused his discretion and you want to overturn his decision, then you need to also make a recommendation regarding the environmental clearance, which, looking at the staff report, would be a categorical exemption. I think that's what Mr. Brown indicated.
Okay. Councilman?
Yeah. I just want to clarify this with the city attorney, because I think sometimes we lawyers speak in terms that maybe are not readily understandable to non-lawyers. So let me make sure that I understand what you're saying and so that everyone else understands. This committee on a 245 motion does not start the review process over again, right? I mean, we don't evaluate the evidence of our own volition. I think what you're telling me, if I understand correctly, is that our only task here is to determine whether or not Mr. Brown abused his discretion, and whether or not the Area Planning Commission then also abused its discretion.
No, you're right on the first part. When you 245 an action, then the Area Planning Commission decision is is gone, and you stand in the shoes of the Area Planning Commission. And the role of the Area Planning Commission as the appellate body, which you now are, determines whether or not the ZA erred or abused his discretion.
So the issue is not whether we agree on the evidence with Mr. Brown. The issue is whether we think Mr. Brown abused his discretion and was so wrong in his assessment of the evidence that he was abusing his scope of discretion.
Yes, but it's case law that we're looking at when we say to make some reference to the evidence that's in the record, that was in the record before the ZA, which you have in the report.
But it's not up to us to be able to sort of make up a compromise solution now. The issue is yes or no, did Mr. Brown abuse his discretion?
That's correct.
Please? Let me tell you why I think that's not exactly right. You're in the place of the Planning Commission. The Planning Commission's allowed to take evidence. They take all kinds of evidence. They're allowed to craft conditions of approval and compromises. They do that all the time. We go to the Planning Commission with a project and the neighbors want it smaller, bigger, different. We do that all the time. You are in the place of the Planning Commission. Now, the Planning Commission does have to find whether they erred, whether the zoning administrator erred or abused their discretion. That's the term. So it's not abuse of discretion, it's erred or abuse of discretion. But you do get to take evidence. And you do, okay, it's not like an appeal in the Court of Appeal.
Mr. Gaines, I'm sorry, I'm reading from the code. I'm reading directly from 1227, and the record on appeal is, it states in the code, it's 1227K, the Area Planning Commission shall base its decision only upon evidence introduced at the hearing or hearings, if any, before the zoning administrator on the issue, and the record findings and decision of the zoning administrator. And then this one is argument, the consideration of arguments, if any, presented to the Area Planning Commission orally or in writing. So that's the standard.
Right. Although the practice, as you know, at the planning...
Mr. Gaines, please.
If you wanted to take additional evidence and someone came in and wanted to give you additional evidence, then you could make certain findings and send it back to the zoning administrator under normal circumstances. But with the 245 review, you only have 21 days from the date that the council moved to take the matter.
How many days we have left?
I'm not sure.
Mr. Chair, the time limit last day for council to act is November 1st.
How many Tuesdays do we have left between now and then?
Tuesday's November 1st.
That's it?
Next Tuesday's November 1st.
That's the last day to act? Okay. It's Mr. Gaines, please. If you don't mind. So at this stage, colleagues, for me this is a tough case. Last comment?
No? Okay.
For you.
Sure. Sean Bales, Councilman Paul Currat's office. Just want to state that, we can, of course, provide those findings, those written findings to you, I guess not at a future date, but, of course, tomorrow, if this is currently scheduled for council tomorrow, if that's appropriate, we can do that for then. I don't know if you have discretion.
Let me just clarify one thing.
Sure.
November 1st, the council has to act or plum committee?
No, council.
Council. It's November 1st is the last day for the city council to act.
Right. Okay. So that means it cannot come back here.
No, that's a charter requirement.
Yeah, it cannot come back here.
So if there is an option to have no recommendation from this body and for it to go to council and those written findings, of course, be provided at council.
If we go with no recommendation, we're going to have a full public hearing again on the council floor.
Okay.
And you want to put Mr. Currat's, Councilman Currat's through that?
No, I don't, sir. But,
I mean, that's what's going to happen.
Right. But, we would like to see a favorable outcome. We feel that discretion.
We're grappling with is we don't have. Well, I understand your point, but right. Your assertions are not focused on the role of this body in trying to find findings right, that can support the assertion that Mr. Brown erred.
Right.
That your assertions are based on process.
Well, no, the assertion is that Mr. Brown erred and abused his discretion. While weighing the factors to deny this case, he put a lot of weight on the placement of that wall, which has nothing to do with his purview. That's a planning decision of the height of the wall, what the wall looks like, does it fit in with the neighborhood. Where that wall is with respect to right-of-way is not a planning decision. Mr. Brown put a lot of weight on that. That is a public works decision. He took something that belongs in the realm of public works and said, as a zoning administrator, I will add weight to this argument to deny it by placing something that is not within my realm. That's where he did err, and that's where he did abuse his discretion. He has no purview there. So that's where we feel that the unevenly weighting of the argument to deny this, a large portion of that was placed in the hands of something that was not within his purview, therefore erring and abusing his discretion because there was no discretion there.
Councilman Kirkland.
Thank you, Mr. Chair. I'm struggling to try to work my way through the impacts of each of these procedural steps. So what was before the zoning administrator was a request for a zoning administrator's determination to allow continued use. The zoning administrator denied that. The 245 is now to take jurisdiction over the decision to deny the zoning administrator's determination to allow. But now like a triple negative. So let's suppose for the moment that the 245 motion failed. That would then mean that the zoning administrator's determination would stand, yes, and that the fence would be deemed non-compliant. Yes. But as far as I see on the record, there hasn't been any order to destroy the fence or anything, is there?
Yes, I think the Building and Safety Department issued an order to comply.
They have issued.
And that was the reason why I think this application was filed.
Okay.
So they haven't taken any action on that order because they gave the applicant and the property owner an opportunity to file an application to make it legal.
Okay. So that application is with Building and Safety is pending? Well, what about has there not been any effort to bring the fence into Building and Safety compliance or compliance with Public Works because of its imposing on the
Building and Safety requires a planning sign-off for a building permit to be issued. That's why we're here. So this would then allow them to get the Building and Safety permits for Building and Safety to go, does it meet mustard? They get their inspections, they get the sign-offs. If it passes, great. If it doesn't, they've got to fix whatever has to be fixed. So that's the process.
So, council member, there's, under Charter Section 245E, it states that after voting for City Planning Commission and Area Planning Commission determinations as opposed to other types of commissions, after voting to bring the matter before it, the council shall have the same authority to act on a matter as that originally held by the City Planning Commission or the Area Planning Commission. So you've got the mandated findings that Mr. Brown was working off of, and those are in the staff report, which you have in your packet. And so it's those findings and the evidence that he relied on that you would be looking at to see if he erred or abused his discretion.
So in that case, then all of these additional photographs that have been submitted today, for example, in this hearing, are not relevant to our consideration. What we should be looking at.
No, they're not. I mean, if you look at, I know people do that, but if you look at 1227K, it does discuss what happens if people want to present new evidence. And they have you have to make certain findings, and then you send it back to, if you think that the findings can be made, you send it back to the zoning administrator to consider those, that new evidence, and then it would come back. The problem here is you can't continue the 21 days under the charter for you to take an action like you can in the code. It's 75 days to act, unless there's a mutual agreement between the commission and the applicant, and it's done on the record in writing. But you don't have that option with a 245, so you're hamstrung with that.
And
unless those photos were part of the record, I don't know if they were.
There's no way for us to tell. We have piles of photographs that aren't even identified, so it's hard to say.
Some of them may have been in front of the zoning administrator. I don't know.
The file was.
So when we act on the 245, we've taken we stand in the place of the Area Planning Commission. So if we don't act on a timely basis, then the status quo is the decision of the zoning administrator that prevails.
Right. That's correct.
And if we do assume jurisdiction and we do act, the only choice is to either determine that he erred or what if we go the other way? I mean, if we go
then if you agree with him, then you just make that determination. You're only required to make those specific written findings if you disagree.
And so if we determine that he erred, then the only other choice would be to find that in fact we can make the findings sufficient to justify the zoning administrator's determination of
that's correct.
To allow continued use.
That's correct.
I have one question, Mr. Brown. Thank you, sir. Mr. Brown? There's a statement you made during the presentation where you observed that the properties that were aligned with this property were also built illegally. Did you make so the walls that are along these properties were also built illegally? I want to make sure that's what I heard.
Yes, that is accurate. The only one that does have approval is across the street, and in my presentation I did identify why that differs than this determination, than this wall that is before you.
And that one differs because of the way it was designed, and it's not as high, and it functions as a retaining wall. Is that accurate?
That's the beginning. Yes, it functions as a retaining wall. The fact that it does have a sidewalk that gives it additional space, that the actual structure is higher, so that as you look at this property, the predominant feature is not the wall, but it is actually the house and the lawn. There are differences between that project and this one, yes.
Do you see any merit in the improvements that are being recommended, given the observations that were made by yourself in this case, where they are willing to change the look of the wall, create more inundations and add landscaping and achieve the goals that you were observing in other properties?
It is a judgment call, and it's a judgment call that when I hold a public hearing, I take into consideration those who are in support and those who are in opposition to help me make that decision. I would suggest that I do not answer that question because I am not holding this hearing, but what I've heard so far is new to me. And so I wish I could help you on that, but I prefer that I have the same right as you do in a public hearing where I can inquire to what is it about this that is not appropriate, if that is the opposition or whatever the case may be.
But if I'm paying, or should I put this, if I'm putting weight, and I put a lot of weight on the council of that district, and if the council member and the deputy went into the neighborhood and engaged the local stakeholders and is now presenting this concern by posing the issues as they have, then it gives us the opportunity to understand his priority as elected official of the area and representing his constituents. Would that be a valid conclusion?
Well, one of the reasons why I did submit photographs of every single property on this street is to assist you in making your determination of whether you believe it's compatible or not.
And that, I think, what's new about when the report was written and what we heard today is the level of changes that perhaps was not provided to you when you made your decision.
That's correct.
And
they were not presented to me.
So there is an increase in value in terms of the level of improvement that perhaps could meet your test given these improvements that were added after you wrote your report. I mean, to me, I'm seeing this logical sequence of events here, and I'm looking at the fact that the council office took the time to go to their constituents, to go to that street, to make that assessment, and to move in a direction, provide a 245 with these new conditions.
Perhaps, but you see, I was only introduced to these changes as of just today. It was not submitted to me and part of the administrative record for me to prepare for today.
No,
I have not been able to evaluate. I haven't even seen their changes.
If I may, Mr. Brown, I'm respecting your decision. I'm not taking away from your decision. What I'm trying to do here is shed light on new information that reflects the level of analysis provided by the council office in introducing these new changes that perhaps could have gone a different way should you have known about them.
Oh, understood.
But you didn't.
But you see, I haven't even seen the changes.
I understand that.
Sitting over there, and I
know it's left their desk. It's here now, so it's our challenge.
I would have to take a look at what they're changing to be able to give you an assessment. I don't know what they're doing.
No, with all due respect, I'm not asking you to go do that.
Okay.
What I'm saying is, I understand you did what you had to do. I respect your work, but there's new information now that pushes me in a direction that assesses the role of the council and how they've gone through this effort to get to this point. That's all I'm saying.
Yes.
Colleagues?
Excuse me, can I just add one more thing? The other provision in 1227L is if you were to make the findings, you can also, it says here that in considering appeals, the Area Planning Commission, which you're now standing in the shoes of, shall be subject to the same limitations regarding findings and conditions as are applicable to a zoning administrator under subsections D and E. So E is conditions of approval. So it's not that you can't condition, but you can't go condition a project so that it's something like bigger, different than was considered. So I don't know if cutting the wall down would be something that's seen as less than, or landscaping, but there is an option to do that as well.
Okay. All right.
To be
colleagues?
Yeah, well, Mr. Chair, the direction I'm leaning is that I don't think the zoning administrator abused his discretion or erred. I think I read his findings, and there are no special circumstances that I heard of that would outweigh his reasoning. Having or the need for my privacy is very, very important, but there are processes and procedures that one would go by to ensure that you get that privacy. I don't think you build and then you seek relief. You try to find different avenues to make that possible. And the conformity is important. There are no special circumstances to outweigh why we would allow the wall to stay up. I just don't, that's the direction I'm leaning, unless I'm bringing the conversation from the public to my colleagues, unless they see it otherwise, that any differently, that a direction why we should go a different direction. But maybe you could convince me of that. I don't know.
I struggle with this on the facts because I'm very sensitive to the concerns expressed by the pickers. I can only imagine what it would be like dealing with paparazzi and that sort of thing. At the same time, there's many other neighborhoods that have other security concerns and privacy concerns and so on that could make the same sort of arguments, and we don't simply allow people to build fences because they want to have a sense of greater security. We have a zoning code, we have fence ordinances, we have regulations that are designed to create some uniformity, but still have allowances for a process for exceptions to that. We have processes that are in place. We have professionals who evaluate the facts of circumstances according to ordinary procedures. And I'm hard-pressed to be able to say that Mr. Brown didn't do what he was supposed to do in evaluating this. It's very, I can't see a basis on what's before me for a finding that he abused his discretion. That being said, I see also a council office working with a constituent to try to figure out some kind of a solution that would be acceptable, that would work for the neighborhood. I can't say that you wouldn't be able to do that. And I'd like to find a way to give them the chance to do that. I just don't feel that I can find that the way to do that is by finding that Mr. Brown abused his discretion, because I'm not seeing that. So if there's another option that we have other than a 245 process to overrule the zoning administrator, which I'm not seeing to be an appropriate process. If there's some other process by which we can achieve the end of helping them to fix the fence, to make it more acceptable, to move it back out of the public right of way, to continue these steps, I'm open to hearing whatever suggestions that Mr. Gaines may have or that others may have.
If I could add, Mr. Correa, I agree with you. I think in other circumstances, depending on how cases get to us, we have that discretion as a committee to work out a solution and come up with some compromise, and we have a lot more leeway. In this one, it seems like our standard by which we're ruling this case is, did the zoning administrator abuse his discretion? And it's just, I'm not seeing that either. So there wouldn't, go ahead, I have a question if afterwards. Can I ask a question?
No, I'd love to hear two attorneys go through this. Because it helps me with the structure of a process, but do you have any more questions? Perhaps they can help me get to it.
I have one question. Mr. Brown, the one argument being made by the council member's office, which is a novel one, which is the reason the argument can be made that there was error in your decision was that the decision as to whether the fence, the wall was built or where it was built out on public property, that is a public works, that should be in public works jurisdiction. It wasn't within your purview of review. How would you respond to that? Or it probably was, but you gave that too much weight, I think is the argument as it goes, in coming up with your conclusion. How would you respond to that?
That was in play. However, it wasn't significant. There were enough issues. It was not significant. There were other issues. What that did is just created another hurdle, even a higher one to overcome, which already I was having difficulty. And then with that and the uncertainty of what Bureau of Engineering would do was I can't take that kind of chance. There are situations where we do that. We will say, depending upon the decision of the other body, this is an approval, but this had enough other issues that I was not willing to allow that process to occur. I do want to note that if you were to find that there was no error or abuse of discretion and that my decision stands, because they have made and I haven't actually seen the plans, but I'm hearing that it's significant changes, that they would be allowed to come back and make an application for a new request, and that will come to a zoning administrator considering the information as in 1227 that says I should, if it's remanded, consider and then make a decision. And if that decision is not acceptable to them, they appeal that to the Area Planning Commission. But that is the only out that I can see where if you want the zoning administrator to actually consider that information, that is a way.
Yes.
Okay, so, great. I see a green light here, and it's not on this button. Okay, did you want to say something, Mr. Bell? No. Council office?
This is Sean Bales, Councilman Paul Craig's office. I apologize for continuing to come up here. I would like to just respond to one thing, and that is, during the zoning administrator's hearing, it was stated by the zoning administrator that when he left that hearing, he had stated, I'm leaning towards approving this. There was a known aesthetic. We knew what the wall looked like. There was no change there. The zoning administrator stated that when he left, what he needed to investigate was the underlying easement, the placement of the wall. That was the only issue. That was the issue that was to be reviewed. When the hearing was left, there was a leaning towards approving it. There was no change in aesthetic. There was no difference. And I apologize, and I'm not trying to make this contentious, sir. So the thing that was being investigated, as per the statement earlier, was the underlying easement, which is there, and I apologize.
Okay, all right. I appreciate that, but we're trying to find a way out here. And I think one approach could be, and help me out, Madam Attorney, is if we were to send it back to the zoning administrator with the improvements, if I'm hearing this correctly, this gives the property owner the option to follow the path they've been trying to get to, if we can send it back to the ZA with improvements that he has yet to assess because they were presented today.
Terry Kaufman, the CS. I don't see anything in the charter that allows you to send it back, because you've got 21 days to act. What I hear Mr. Brown saying is the property owners can go to the planning department and file an application. You don't send it back for that. They just go and you know, not having spoken to building and safety about this, if they're made aware that that application is being filed and pending, they may not do anything with the order to comply. That's pretty standard for them if there's no life safety issues. So, you know.
Okay, so they just expand.
So council just needs to take its action. The committee can take its action or move it on without a recommendation, whatever. Council will take its action, and then the applicants can still go to the planning department and file an application with some other design, if that's what they want to do. I mean, it could be full council has a different determination than what you may recommend.
Right. So, did you want to say, Mr. Gaines, and let's close it after this? This is it. Keep it here, it dies.
Well, I mean, your city attorney gave you an opinion. What it actually says is you stand in the position of the APC. The APC has the ability under the code to send it back. So I don't understand why the city attorney is saying that you can't act within the 21 days, and your action, like an action of the APC, would be to remand it back for hearing in front of the zoning administrator to consider whatever additional evidence or whatever you're going to do. That's much better than having to make a brand new application and when we have these processes going forward. Not only from the cost, from the timing. I mean, if you have specific information here, and I think you can do that, and so you will take an action within the 21 days, and you can do that. I will tell you that this is a wall on this people's property, and they've been through a whole series of hearings. They wouldn't be here except that the councilman came up and really thought that there was a way to resolve this, and as you know, has asked you to resolve it. And what the councilman has said is that that they do believe that the zoning administrator erred. And they erred because he considered the right-of-way when that was not in his purview. He erred when he said it wasn't compatible with the neighborhood when there is substantial evidence that it is compatible with the neighborhood. That he erred because of the uniqueness of the property, that this is a side yard instead of a front yard and it's a downhill property, and because of the evidence of the specific nuisance at this site. So there are places. Forget abuse of discretion. I hate that term. Mr. Brown is a wonderful zoning administrator. Everybody would hate to say that he abuses discretion.
He's a good guy.
But did he err using this evidence, which is frankly undisputed? The issues that I just laid out are undisputed, that there's evidence in the record on all those. That's what Councilman Crutz is asking you to do after his personal observation, after him saying, look, there is a compromise here that we can include. There are conditions of approval we can include. So I believe you could send it back. You'd send it back to go through another several months of process and hearings. I also believe you can find that there was error and make the determination that the councilman is asking you to make.
Thank you very much. Thank you. Okay. So let's close this public hearing.
Okay,
no
just
more comments.
one last point. Terry
Yes.
Copeland, Messiah City Attorney's Office. So as I mentioned, if there's new evidence and you want to send that back, you have to make specific findings. I'm just doing it from memory now because I lost my copy of the code. But it's that that evidence couldn't have been presented in the exercise of due diligence before the ZA, and I think that's the main finding.
Well, okay, so colleagues, because of these, I'm going to put this, goals set by the council office, and I'm going to follow their lead on this. They did suggest that we send this forward without recommendation. My hope was that we could, given the amount of improvement and or change that was heard after ZA, but we can't weigh that anymore. It's not part of our purview because of the standards as Councilman Rizal was mentioning, and the processes that have been defined very clearly in the charter and articulated by Councilman Krikorian. I would say we move this forward to the full council without recommendation and allow the facts to be stated and provide the council member an opportunity to make his case before his colleagues. Because at this juncture, it doesn't seem we have enough on the table to move one way or another, it seems to me. I think we're trying to find it, but it's just not there.
When will it go to council?
It would have to go by Tuesday or tomorrow.
Scheduling council tomorrow.
Tomorrow. So that's what I would put on the table.
Okay.
Is there a second?
Second.
Oh, the new findings.
Well, our other option would be to have this continue to, it has to be by council, acted upon by council by next Tuesday. We don't have another meeting.
Right.
Okay.
But it's in council tomorrow. Technically, it could be continued to the Friday meeting or to the Tuesday meeting.
Yeah, and let's do that. We allow the council office some time to look at this new evidence, and I think if we continue this to have it in council Friday or schedule.
Well, he would have the discretion to continue it tomorrow and Friday.
Or Tuesday.
He can take it all the way to Tuesday.
Yeah. Okay.
And then we'll give him that flexibility.
Okay.
All right? No recommendation.
No recommendation.
All right? And it's no recommendation.
No recommendation. Well, within council tomorrow, Councilman Kratz can continue it to the Friday meeting or to the Tuesday meeting, which is a deadline.
Tuesday's the last day to act.
Yes, sir.
Okay, that takes care of that item. Anything else, Roberto?
Public comment.
Yeah, one public comment card, Mr. McQuestion.
Jim McQuiston. I detected a councilman who is not on the committee sending his representative down here in violation of the Brown Act and pleading a case for the council district. And that's something that some of the councilmen have already pointed out, and they refrain from doing that. But
Would you mind responding?
what I did want to talk to you about is, you see exactly, this is exactly what I brought you under for. We do have to work on this because people do not realize that when you sit in the place of like the APC or whatnot, you are really constrained, very constrained, and substantial evidence is what you're going on. If he didn't put up some substantial evidence, then you have something to overturn him on. But otherwise, you don't have a leg to stand on. And we've been kind of pushing this off. I'll tell you, I've been in some meetings where a city attorney has been there, and we get into a knotty question, and he always says, what can we get away with? The problem is that it costs a lot of money to put a court action in. You know, the Civil Rights Act of 1964 was a failure until they put in the Civil Rights Attorneys Fee Awards Act. And when that happened, all of a sudden we got civil rights in the United States because people then were empowered. People now are waking up. I see more and more people filing suits, and every one of these suits wins. It's terrible, and we will get a very bad reputation. We want to get everything straightened out.
Thank you very much. Roberto, do you want to make any comments?
Mr. McQuiston indicated that there was a council representative here. I believe he was from Council District 5, and as a representative of a case being discussed in the committee, he could very well provide his comments.
And actually, Mr. Chairman, if I may just follow up on that so that we don't go back and forth with the dialogue. This is a public meeting. Anybody from any council office can come and sit in this meeting, and we could have as many as 4 council members, representatives, speaking at the microphone. There wouldn't be a majority of the council. There would be no violation of the Brown Act.
Thank you, Councilman. All right. No one else here for public comment? This meeting is adjourned.